Hi, everyone. So great to see everyone. Many of you we were able to see in person this week, which was such a pleasure. At a conference, it feels like in person is back, which is really good to see. While we're waiting for folks to join, take a note for our new brand that we'll release with our new website at the end of the year. We're pretty excited about it. Robbie, let me know when you want me to get us going.
Yeah, let's give folks maybe just like 30 more seconds to hop on. And
Everybody take a deep breath. It's almost, what is it? We have one more week to the end of the month.
I know.
Where did this year go?
I don't know. I don't know. I mean, I think our calendar is going to have to start looking at January already for all of you. Hi, Anya. Good to see you.
All right, Timmy, I think we're good to go.
Okay. Thank you, everyone. Welcome to Connecting for Better Health. We're super excited about our discussion today. We will be looking at reproductive health key considerations as we go forward, and are joined by our colleagues and attorneys at Hooper, Lundy, and Bookman. So Robbie will be helping to facilitate that discussion. We also are going to continue our discussion we started on our last call about the qualifying health information organizations that Lori Hack and KHI presented, for us to be able to really kind of think through our response to the data sharing framework and the data sharing agreement. What is it going to take to be a QHIO? So I welcome you to kind of bring your thoughts there. We also will be debriefing on the several listening sessions that have been also sponsored over the last few weeks. So we have some key takeaways. We'd love for you to be able to share your key takeaways too. And many of that will also address some of the grant opportunities that we are preparing to respond to. And then we will close with news and events. As always, please, if you're new to us, and if you're not new to us, let's use the chat to introduce each other. It's a great way to network. And again, thank you for all of you who joined us at CAP this week and our networking event. It was a great success. And I just think it's so great for us to be able to, really continue these conversations that we start here, but have them offline and bring them into our practice. So let's go to the next slide, Robbie. Connecting for Better Health, we are a coalition of diverse group of stakeholders, as you see here, dedicated to advancing health information exchange in California. Our policy priorities in 2022 include really working on funding and ensuring that we have the funding to be able to sustain the infrastructure that we know needs to be built. In addition, we really are focused on holding the state accountable for all of this work that's being done around the data exchange framework and the data sharing agreement. And kudos to all of you. I think we've been doing such a great job of monitoring that progress and keeping that progress going at a pretty quick pace. And then also, and we'd love to make sure that this is clear that we really envision an infrastructure where we have multiple regional and HIOs sharing data with each other, and that we are really closing any white space that we see across the state. With that, if we move to the next slide, you'll see how we manage our programming. We really looked at several priority use cases and what connects those use cases. What are those common elements, common considerations that we really need to focus on, and hence why we're here today, looking at privacy and consent information and policy to be able to help data exchange thrive. Robbie, I'm going to hand it over to you to introduce our speakers.
Yeah, thanks, Timmy, and hi, everyone. So fun to see so many of you at CAP this week. Still recovering, but really fun to get together with folks on Monday night in particular. But yeah, I think, we heard from many of you over the last few months that, there's high interest in learning more about, the implications of the Dobbs decision on sharing, reproductive health related data. And I know several of you were at Civitas, so the Civitas conference back in August, and there was a really great breakout session led by Stephen Lane. And Devin McGraw around, what does this mean in terms of data sharing for HIEs, for national networks, and what are some of the legal and operational and technical implications? So we really wanted to bring that conversation here today, with a California lens in particular. And, we're really excited to have Andrea and Carrie with us to really give an overview of, where the law is, what are some ideas for where we can go next, and really recommend folks, please put questions in the chat as the conversation goes along, and we can definitely weave those in as we go. So without further ado, Andrea and Carrie.
Oops.
Well,
Is everybody still there? Andrea, are you there? I think we just had a little bit of a frozen internet.
yeah, sounds good. Well, maybe I'll just take it away while Robbie
Okay, yeah, take it away.
catches up. But thanks to Robbie and thanks Timmy for having us today. Really appreciate the opportunity to be here. And I know Robbie sort of framed our introduction, but by way of background, Carrie and I are both associates at the law firm of Hooper, Lenny and Bookman. We, specialize in healthcare law. And Carrie and I both regularly advise clients in the digital health space, particularly around privacy issues at the federal and state level. So turning to our agenda for today, I want to kind of frame the importance of our discussion. As a reminder, on June 4th of this year, the Supreme Court released the Dobbs opinion, which reversed the 1973 Roe v. Wade and the 1992 Planned Parenthood versus Casey decisions by holding that the Constitution does not confer a right to abortion and that state legislatures may instead regulate abortion. So, this decision clearly very shocking in many regards, but it didn't really come as a surprise given the leaked draft that was released earlier in the year. And so after the decision ultimately was published, we saw a fair amount of state activity, mobilizing quickly to enact quite the patchwork of laws ranging from prohibiting abortion altogether to restricting it at certain levels to, for example, states like California and Massachusetts that really focused on putting measures into place to enhance access to abortion and related reproductive health services. We're also seeing some states considering laws that prohibit residents from obtaining abortions in other states like California, and even punishing those who facilitate or sort of aid and abet in the procedures. And so, of course, state prosecutors and law enforcement agencies, I think it's fair to say, will likely turn to patients' information, from providers, from health plans, from all these companies that hold and collect such information and use it kind of as or exploit it rather to, convict folks for civil and criminal violations of these anti-abortion laws. And with this, there's really driven this renewed focus on health information privacy and for sensitive services like abortion, and questions around whether existing laws, both at the federal level and within California for us, sufficiently protect patients, and their healthcare providers and the plans that keep and hold this information. On top of this, as you are all very familiar with, we have the state and federal level efforts like TEPCA and the California Data Exchange Framework and the info blocking rules that really drive or even mandate in some cases the exchange and interoperability of medical records. And so it's kind of a conflicting balance between ensuring protection versus ensuring interoperability of medical records, including reproductive health information. So for the presentation today, we're going to kind of briefly summarize the available sources of protection for reproductive health information, both at the federal and state level here in California. We'll take a look at the impact of the data sharing obligations and kind of wrap up with what I really hope to be as an open discussion on options that we can implement, both in terms of regulatory and legislative measures that we can push for and or sort of operational measures that will enhance the protection of reproductive health information. And so briefly then on to the next slide, just the usual legal disclaimers here that the purpose of the presentation is really just for educational purposes and not intended to, nor does it constitute legal advice. If you do have any specific legal questions, just a reminder to please consult your legal counsel. And then, so how we got here, I think this is probably pretty familiar to everyone, but just as a reminder, in 1973, the Roe v. Wade decision by SCOTUS upheld established the constitutional right to abortion under the 14th Amendment's Due Process Clause. Then in 1992, we had the Planned Parenthood versus Casey decision, in which we saw the court accept, albeit stricter limits on abortion, but while also reasserting and upholding Roe's central principles. And then most recently, particularly following the changes in composition of the Supreme Court, we see the Dobbs versus Jackson decision in which the Supreme Court considered the constitutionality of a 2018, I believe, Mississippi law that banned abortion at 15 weeks. And ultimately, the court, overruled both Roe and Casey, finding that there's no constitutional right to an abortion, and ultimately deferring to the states to regulate, and in doing so, abandoning 50 years of precedent. So the decision really left open the door for states to restrict or ban abortion. And as of now, there are about 13 states that ban the procedure outright, and then a number of other states that, while they do permit the procedure, have significant restrictions in place, for example, banning it at 6 weeks, often before an individual knows they're even pregnant. And some of these state laws have been held up in courts, particularly as advocates like Planned Parenthood have sued to block enforcement. So, it's fair to say that where we end up is it's really quite a patchwork of laws across the country in terms of access to abortion. And as I noted earlier, in an effort to enforce these laws, we will certainly be seeing and have already seen state prosecutors and law enforcement agencies, and potentially in the future, to the extent the administration changes, federal law enforcement agencies as well, seeking patient medical records and related healthcare information, as a source of evidence for civil and criminal violations of these restrictive laws. So I think at this point, it's really critical that both patients and their providers, health plans, anybody who's holding or collecting reproductive health information, really understand when reproductive health information is protected from disclosures to law enforcement agencies and when it's not. And so at this point, I'm going to turn it over to Carrie to talk a little bit about the federal law that everybody's familiar with, HIPAA.
Great, thanks, Andrea. Yeah, so I'm sure you all are probably pretty familiar with this, but when it comes to privacy protections for reproductive health information on the federal level, most relevant is HIPAA, which establishes a national floor of comprehensive standards for the protection of protected health information, or PHI. So in general, HIPAA applies to covered entities, which includes, healthcare providers, health plans, and of course the practitioners themselves, which hold or transmit PHI. HIPAA also applies to business associates of covered entities, which includes persons or entities that perform certain functions for covered entities involving use or disclosure of PHI. So these are things like billing services, claims processing, or like utilization review. Also the HIPAA applies to the workforce members of covered entities and business associates. So these includes folks like employees, volunteers, trainees, and others who perform work under the covered entities or business associates' direct control. In the post-Dobbs context, much of the concern related to a component of HIPAA called the HIPAA privacy rule. So as a general rule, use or disclosure of PHI requires individuals' authorization. However, the HIPAA privacy rule establishes specific rules where use and disclosure of PHI without the patient's knowledge or authorization is permitted. So HHS's Office of Civil Rights, which is the office that is responsible for enforcing HIPAA, released specific guidance addressing permitted disclosures and their limitations under the privacy rule after Dobbs. In particular, HHS addressed 3 specific instances of permitted disclosure, reproductive health information. So the first being disclosures required by law, second being disclosures for law enforcement purposes, and the third, disclosures to avert a serious threat to health or safety. Note that HIPAA also includes permitted disclosures in other instances, but these are some of the key ones, at least in this context. It's important to note that disclosure may be permitted under HIPAA in these instances, but HIPAA does not itself require such disclosures. So to start with the first one, disclosures required by law. HIPAA privacy rule permits covered entities to make disclosures of an individual's PHI to third parties without an authorization, where such disclosure is expressly required by another law, and the disclosure complies with the requirements of the other law. So OCR's guidance provides an example where state law generally prohibits abortion, but let's say it doesn't specifically require reporting individuals to law enforcement. And let's say, for example, a hospital workforce member suspects a patient received an unlawful abortion. OCR states that in these circumstances, HIPAA would not permit the covered entity or the workforce member to disclose PHI under the permitted by law exception, as the law itself does not expressly require such disclosure. For the second, disclosures to law enforcement. So the privacy rule also permits the disclosure of PHI for law enforcement purposes, pursuant to certain legal processes, such as like a warrant, a subpoena, or summons. So for example, OCR provides an example where law enforcement officials, let's say, requests from a clinic or a hospital to turn over records regarding abortions performed on site, but that law enforcement official doesn't have a warrant, a court order, or any other enforceable mandate. OCR notes that in this instance, HIPAA would prohibit disclosure. And then the last one, disclosure to avert a serious threat to health or safety. The privacy rule permits disclosure of PHI where the covered entity believes in good faith that disclosure is necessary to prevent or lessen a serious and imminent threat to the health or safety of the person or the public. And such disclosure must otherwise be consistent with applicable law and standards of ethical conduct. So here, OCR provides an example where the patient informs that the healthcare provider, let's say the patient informs them of their intent to seek an abortion in a state where abortion is legal, so like California. OCR states that disclosure here would not be permitted for several reasons. So first, statements indicating an individual's intent to get a legal abortion in another state or to get treatment for something like an ectopic pregnancy or for other complications doesn't qualify as a serious and imminent threat to the health or safety of the person or the public. And second, OCR states that it's generally inconsistent with professional standards and ethical conduct to make such disclosure. So, for example, disclosure here, as OCR states, would seriously compromise, the integrity of the physician-patient relationship. And OCR notes that disclosure itself may increase risk of harm to the patient. So to note that in all of these instances, even if permissive, HIPAA does not require disclosure under HIPAA itself. And HIPAA would only permit disclosures to the extent, to the minimum extent necessary. So for example, a covered entity would be able to disclose PHI, required by law, only as to information specifically required by such law. Or, where disclosure is to law enforcement to comply with a warrant, the covered entity could only disclose PHI to the extent specified in that warrant. Okay, if you can go to the next slide. All right, so that being said, HIPAA has its limits in this post-ops context. So first, HIPAA itself may permit but not require disclosure, as you mentioned. However, that means that HIPAA would not be a shield where disclosure may be compelled by state law. So for example, HIPAA doesn't require and mandate that a covered entity need to disclose PHI pursuant to a warrant, but the covered entity could face penalties under state law for not complying with the warrant. Second, a second limitation is that HIPAA is really limited in its applicability to all businesses and entities which have, and maintain sensitive reproductive health information. So for example, HIPAA may not apply to certain technology companies or, direct-to-consumer mobile health applications that, for example, operate menstrual cycle or fertility tracking apps, or even companies like Google or other search engine companies that maintain user search histories. Here, we just want to note that the FTC has released guidance on these circumstances, noting some of the laws that are within their authority to deal with misuses of reproductive health information. The main is Section 5 of the FTC Act, which broadly prohibits what's considered unfair and deceptive acts or practices, which could come up in several ways here. So for example, the FTC Act defines a practice as unfair, in part if it would cause or is likely to cause substantial injury to consumers. the FTC's guidance notes that exposure to reproductive health information can, in many cases, subject people to such injuries such as, discrimination, mental anguish, or other serious harms, such that disclosure may be prohibited by the FTC Act. Another example the FTC points to are sort of where instances where companies claim that data is anonymous or has been anonymized, which the FTC notes are often deceptive claims since data can then be re-identified later. So that being said, HIPAA and other federal laws continue to serve really important roles here, but there are still pretty big and significant gaps in the ability to fully protect the privacy and confidentiality of reproductive rights. So with that, I'll turn it back to Andrea to talk more about privacy protections under California law.
Yeah, thanks, Carrie. I did see a question on medication abortion. I don't know if I should answer it now, or do you want me to hold off until the end?
Andrea, I think it would be great. Yeah, just if you see ones that you want to address, please do.
Yeah, okay. So I think there was a question from Mary Sarah Jones regarding nuances in the laws to differentiate medical abortion and the limitations. And just to briefly answer that, yep, there are a ton of state laws that are specific to restrictions around medication abortion, particularly when it's delivered via telehealth. So for example, a number of states require that a physician prescribe an abortion-inducing drug rather than an allied health professional, even though it's usually within their scope and practice authority to do so. There are a number of other states that explicitly require the physician to be in the room when the patient takes medication abortion pills, and a number of other specific requirements that prohibit, for example, the delivery of medication abortion via mail, and then also explicit to the use of telehealth, banning telehealth for the delivery of medication abortion. So certainly there are, that's something to consider for providers licensed in California, sitting in California, who are treating patients in other states and prescribing medication abortion, another area of laws to be aware of to the extent this is within your practice. So now kind of turning back to the presentation and the California protections for reproductive health information, the CMIA, Confidentiality of Medical Information Act, really is kind of the analog to HIPAA in this state and the primary law addressing the protection of medical information in California. But there are a number of differences here that I think are really critical to note between HIPAA and the CMIA. So for example, the CMIA and its restrictions on the use and disclosure of medical information apply not only to healthcare providers and plans, but also more broadly to any sort of business that's, quote, organized for the purpose of maintaining medical information. So unlike HIPAA, this would cover the devices and mobile applications that Carrie mentioned that are tracking fertility or your menstrual cycle or a user's sexual activity, etc. Additionally, the CMIA does not apply to medical information that's, quote, sought by law enforcement agencies. Rather, it defers to the California Penal Code in these instances. And so providers or anybody who is subject to the CMIA can only disclose medical information to law enforcement if and only if the disclosure meets one of the specific exceptions, and they're laid out here. But for example, these include if they're in accordance with the prior written consent from the patient, an appropriate court order, or they've been authorized by a valid search warrant in the state. I will note, though, the CMA doesn't prevent covered entities from making unsolicited reports to law enforcement agencies if it's otherwise permitted. So something to note there. And then additionally, the state attorney general has released guidance post-Dobbs, just reminding companies and providers and plans who are subject to the CMIA that it does intend to enforce these requirements. So certainly, at least in California, the attorney general is going to be very active in this space. So something that we'll likely see in the pipeline. And then in addition to the CMIA in California, thank you, Robbie, we also have the California constitutional right to privacy, and this is under Article 1, Section 1 of the Constitution, which expressly protects the right to privacy, and this does extend to a patient's medical and psychiatric history. And we've also seen a number of providers, raise the constitutional right of their patients to protect their patients' records from disclosure, usually pursuant to requests from regulatory agencies like the California Medical Board when it's investigating prescribing practices of controlled substances. But still, at the end of the day, the courts in these instances really focus on the balance between the privacy rights of patients on the one hand and the need for the information and the litigation, and whether there's sort of a compelling interest to overcome the patient's right to privacy. So, I do think, at least for purposes of California, the Constitution does offer this another source of legal protection for patients' reproductive health information. And then on top of this, you will also see in your ballot come November, the Senate Constitutional Amendment number 10, which will enshrine in our Constitution the explicit protection to abortion and contraception. And then we've also seen a variety of legislative measures crop up in California to protect the privacy of medical information in individuals, most often for those seeking abortions in the state who come from, Texas or Arizona or elsewhere, and then the, providers or anybody else who is facilitating in that process. And so, the kind of big ones here are AB 2091, which really seeks to enhance the privacy protections under the CMIA and also the health insurance code in California for medical records that relate to abortion care by prohibiting disclosures to law enforcement and out-of-state parties that are looking to enforce another state's abortion ban. It would also prohibit individuals from being compelled to identify or provide information that would identify somebody as having sought or obtained an abortion in the state if that information is being requested pursuant to another state's laws, which are directly interfering with the individual's right to get an abortion, or it's some form of civil action that's authorized by another state's law to punish somebody for seeking or obtaining an abortion. And then there's also AB 1242, which really focuses on prohibiting California-based technology companies like Facebook and the like from providing records or information to law enforcement agencies pursuant to an investigation or warrant or subpoena request, that ultimately are derived from an investigation relating to an unlawful abortion in that state. So, I think these new legislative measures are really important, but they do also raise some pretty complex legal questions, given the direct conflict between California law and other states' anti-abortion laws. It also puts a lot of providers and companies kind of in this uncomfortable position of having to choose between complying with the California law on one hand, and another state's mandate to disclose information, on the other. So I do think it's likely that kind of given this very obvious clash that, we'll likely have to require some clarity from state courts or from courts down the line, maybe even including Supreme Court. So that will be interesting to see how that plays out. And then kind of wrapping up here, I think we really do want to talk about the data sharing obligations as well. And, keeping that in mind with the sort of mandate to provide reproductive health information, more broadly. And so at the federal level, we have the information blocking rules under the 21st Century Cures Act, which really kind of shifts the analysis, around whether to disclose information on its head. So, with HIPAA, for example, it doesn't, as Carrie mentioned, it doesn't really require a covered entity to ever disclose protected health information, but this sort of shifts under the info blocking rules such that unless there's some sort of applicable exception, an actor who's subject to the rules really has to provide access to or exchange electronic health information. Otherwise, any sort of practice that kind of limits those practices could constitute information blocking. And then, we also have efforts at the federal level like TEFCA, and then the California's data exchange framework, which, further really seek to drive interoperability of patient records. And I know most of you are familiar with the statewide data exchange framework too, which mandates for participants, the quote, real-time access to or exchange of health information among participants. And that would obviously cover reproductive health information because at least as of now, neither the data sharing agreement nor any of the policies and procedures under the data exchange framework offer our patients, kind of a choice to potentially opt out of having their sensitive data shared over the exchange. So, that may be kind of another area or future push to encourage Cal HHS to, expand policies that would actually protect reproductive health information going forward within the exchange. Which I think brings us to our last topic where we really kind of want to crowdsource here. And Robbie and Timmy, please feel free to weigh in too. In the wake of Dobbs, I think it's really critical that we focus on ensuring the privacy of reproductive health information, mainly to make sure that patients are comfortable seeking needed care and not, driven away out of fear that their information could be released and they could be prosecuted down the line. So, we came up with a couple of legislative and regulatory measures, both at the federal and state level. And then on the next slide, some operational measures that could be put in place. And I'm, happy to discuss these, or I don't know if it makes sense to kind of crowdsource at this point, but I think that kind of wraps up our presentation.
No, thank you, Andrea and Carrie. And, I think we'd love to take questions from folks on the call or ideas. I know when we were at Civitas, some of these ideas came up, and would love to hear from folks here, regarding some of these ideas, like data segmentation that came up, but, especially if we're thinking about things like pregnancy related data, that often is in an EHR and, may not be with a clinic, maybe that specializes right in like reproductive care. Like, how do we segment that data within the health record? And, what are some of the challenges to that? Dan, I see you put in, please expand on the consent options. Could you maybe expand on that question a little more, if you don't mind?
Yeah, I think with that idea, it was kind of focused on, maybe companies and providers that collect or, obtain and document a patient's reproductive health information, whether or not it makes sense to inform them at the time that they're receiving the services around the potential implications of having their reproductive health information data tracked and recorded, and for, providers specifically documented in their electronic health record. And whether or not it makes sense to consent to having, that information tracked and recorded, or some form of, request to have their data segmented separately, such that it's not within the main component of their EHR, for example.
So the suggestion is that those providers make this a specific consent option. I think that's what you're saying. I think it's the slide before this. I was a little confused by that final point, at least in the doc. Currently, patients have no choice to opt out. I guess I was really confused by that wording, because isn't it fair to say that patients always have a choice to opt out as a provision?
Yeah, no, that's a good point, Dan. I meant to say that there's no explicit opt out with regard to reproductive health information in particular. Thanks for that clarification.
Thank you.
Is there an expected timeline for AB 2091 to take effect? Because we're talking about this at our coalition, and thinking about where these things might come into play. And if that takes effect, then it's an exception underneath the information blocking rule, right? Because it's covered by a state regulation. Therefore, it does become segmented, and it doesn't get shared into any sort of interoperability connections, right? Whether it's Care Equality or Commonwealth or the State Data Exchange Framework or other regional HIEs. And so there is a piece of that as far as progress notes, but there isn't like, if there is some form of complication that gets onto a problem list, right? And then where are we talking to clinicians about this, and what type of medical risk does this put patients at? If they have a procedure that's available, but it is segmented, and whether or not a break the glass is available, but then, there's a complication and they head to the ER, and that ER provider doesn't have the ability to access those records, right? So there's this very big piece of missing of this conversation.
Yeah,
and I'm not sure where to go with it.
So I think just to kind of break out your questions a bit. So For context, AB 2091 was an urgency statute, which means it went into effect immediately after it was authorized and signed by the governor. But it's very limited in its applicability, right? It doesn't necessarily preclude the ability to share reproductive health information across exchanges. It rather focuses on the ability to turn over records pursuant to a request from an out-of-state law enforcement agency or official, right? So it could conceivably be, under the information blocking practices, it could a provider could use the exception, to comply with state law in order to preclude disclosure or access by a requesting law enforcement agency under AB 2091, but it wouldn't necessarily limit the exchange among providers themselves.
No, thank you for that clarification, Andrea. Maybe one last question if anyone has one. Well, I really think Andrea and Carrie. Oh, Timmy.
Robbie,
Yeah.
I don't know. I'm really struck by, like, where do we go from here? Are there some key priority new legislation that you would recommend that we should be thinking about and pursuing? I mean, looking at the team that's here today that we should be leaning in on. Should we be creating a extra task force, to really think through at a detailed level the data sharing work here? Task force that we can't just leave this, I guess is my I don't have the words, but
well, I will say, there are a lot of efforts both within California, but then at the national level broadly, among stakeholders. For example, like the National Partnership for Women and Families is really pushing HHS, and a couple of other US senators have signed on board to encourage the agency to adopt amendments to the privacy rule, for example, that would really focus on treating reproductive health information as a specialized category of PHI, much like HIPAA currently does with psychotherapy notes. So I think that's an area that's really worthy of exploration. There's also, some push at the federal level for legislation that specifically protects from, companies that are tracking this kind of information, particularly like geolocation data. So say if a patient travels to another state, a law enforcement agency could subpoena the tracking data to go after them, especially where it says, I went to Planned Parenthood on X date, that's theoretically could be used as evidence. And so there is some push for legislative measures to protect that information in the hands of those kind of data companies, which would help, because as Carrie mentioned, HIPAA has such a, it is broad, but limited in its applicability to which actors it covers. So I think those kind of, we just need to make sure we keep that momentum going, both at the federal and at the state level, to ensure, privacy is really protected here.
and thank you so much. And I think, Robbie, as a next step here, we would welcome additional thoughts offline to be able to then create a fact sheet or a paper that we can put out as part of the coalition.
Yeah.
And there's just going to be more on this, and thank you so much for tackling such an important topic.
Yeah, definitely. And I'm more than happy to be available if anybody has questions. Please feel free to shoot Carrie or me an email. Here's our contact information, and thank you again so much for having us today.
No, thank you for coming. And yeah, I think as a next step, we'll share that issue brief with folks. And I think there's definitely ideas that we could shoot off to OCR, Cal HHS, and even the legislature. And then, I think something else for us to just chew on here is how, when it comes to operational or technical implications, and we discussed this a lot at the conference, how do we make sure this makes its way into national networks, and maybe how HIEs operate, and what are some of the implications there? And I think that's a conversation we can keep having here at the coalition as well. Because as we explore all the different use cases, right, where people might be seeking information, it trickles down to, information in someone's medical record around whether they're even pregnant, right? And I think there's just lots of rabbit holes we could go down potentially, but, just thinking about some of those use cases as well. So I appreciate your time today, and thanks for coming.
Thank you.
So I think, yeah, switching gears a little to a drier but still important topic. We would love, to follow up from last week's discussion around qualifying HIOs under the Cal HHS data sharing agreement and policies and procedures. I think just for context, Cal HHS is hoping to come out with a policy and procedure soon on what it will take for organizations to become qualified to be able to receive funding and be designated by the state as an HIO. And really appreciate, Lori, your explanation last week around some of KHI's ideas when it comes to how we might qualify these organizations. I think we'd love to hear from folks. We discussed last week, these ideas from KHI around being a not-for-profit, some of the business considerations as well as technical capability to really serve signatories to the DSA, be part of C10 as well. But would love to hear from you all. Are there other considerations in addition to these? What are some ideas folks have for KHI as well as the coalition in terms of kind of putting together a response and sending ideas to the state as well?
Anyone have additional areas that you would like to see addressed? This came up this week as well, is that it's unclear whether or not an HIE or qualified HIO is required to be a signatory to the DSA. And I guess I'd assume that it would be. So maybe that's also a requirement.
Deanne, they're not listed as a signatory. I don't even think they're listed as a maybe. I submitted a question to CDII within the past week asking whether there's any parameters of who voluntarily becomes a participant.
Yeah.
And it was like a note to myself to go digging into the past year of written information to see if anybody and their brother's allowed to say, I'd like to sign this DSA. So I'm curious also if anybody
brother
knows.
and sister.
Right?
Which is interesting because, during the stakeholder advisory group meetings, I feel like there was discussion that really signaled like the QHIOs would be required to sign. And I mean, at the least comply, right? If you're going to be able to be qualified, you need to, basically comply with the letter of the law, which would be the DSA too. So, but I saw that in the Q&A around the education grants, Deanne, and thought that was curious too, around not requiring them to sign.
Yeah, so that's potentially it's an appropriate shortcut to, instead of revising the legislation or adding to it or via new legislation, to put it into the condition or the definition of what is a qualified HIO, that they must sign the DSA.
Mm-hmm.
I would support that. Dan, have you thought through that? I see you're off camera, but I'm going to pick on you. Oh, Lori. Yeah.
I'm like, what?
Yeah.
Lori or Dan? Go ahead, Lori.
Yeah, so there is discussion right now between CDII and KHI about that, and I think there is no legislation requiring it. I think because there wasn't a really clear understanding of the role of HIEs in California, but I think that certainly will be an opportunity to voluntarily participate and sign. And as Deanne mentioned, probably on the long list of amended language for the legislation for next year.
That makes sense. I think that tracks with what Cal HHS said, that they will be seeking legislation for more authority, but it does seem like at the least you need to comply. They'll need to comply, right, with the DSA in order to help participants share data. So.
Speaking for one HIO, yeah, it should be required, but I think people are hedging their bets given that we don't have the definition of a qualified HIO. So Happy to sign. I think we should sign. I think the state should sign. Absolutely.
I think that that would be a reasonable reasonable feedback to the state to say that it should be a signatory. To be QIHO, you have to sign it. Anything else that's missing here? Yeah, sorry, Robbie.
No, you read my mind, Timmy. Any other thoughts around, what the nuts and bolts of the qualification process should be?
I think, oh, go ahead, Felix.
Yeah, hey, first of all, yeah, thank you for basically, adapting Lori's proposed information, which I think, between Dan and myself and the other HIOs that are on the call, we are strongly aligned on. We think there is a lot of rationale for, again, recognizing that AB 133 is quote unquote technology agnostic, that the state has a vested interest in a designation process of its own choosing to really stand up an infrastructure, right, that meets very specific California needs. And I think that's really captured here in elements like being California-based, nonprofit, and so forth. So that was just sort of some throat clearing to really validate, I think, why we think this is very, very important, and that the coalition would be very well poised to recommend. Second, on the issue of HIOs signing the DXF, I don't know that it would require. Maybe it does. I mean, I guess I don't know that a wholesale change to the statute to AB 133, because wasn't it just like a couple of days ago where there was an update from CDII that they were amending the DXF for the DSA to strike out, themselves as being a party to or a signatory to the data sharing agreement. And if they can do that, I figured they could probably as easily incorporate qualified HIOs as being required signatories. And again, I echo Dan and Lori. There's absolutely no reason why we should not be required to sign the agreement. For instance, if we're queried for data, we should obviously be expected to respond, right? That's the whole point of the DXF to begin with, or one of the main points. So yeah, in terms of what could also be added to this, which I think is really, really great, is something to the effect of, it sounds self-evident, but really nailing home that a qualified HIO must be able to, meet all of the required data sharing purposes of signatories that choose to use them as their intermediaries, as well as be able to exchange, the required health and social information as, laid out in the policies and procedures. I think there was some draft language that we had included as part of KHI's initial proposal, and if that's not yet been shared with the group, then I think maybe we can see if we can pass that along.
Yeah, that would be great.
Thank you. And I just put in the chat too. I know that when I hear a qualified HIO, I immediately go back to the CalHOP work, and there was a qualification process for those participating in CalHOP. And I'm just wondering, Lori, if KHI went through and did a crosswalk with those requirements, or should we do that too?
Yeah, we did in preparing our documents. Well, when I say we, I mean Mimi Hall did, and Felix did a lot of the work. They cross-checked not only the CalHOP qualifications, but also TEFCA. And so that's why, we have kind of a little bit of both, and then an update from what the C10 already requires of its participants. So I think we're coming up with the sort of the best of breed approach, along with a roadmap. So So for example, with fire, that's a great standard. That's something that could be utilized and should be utilized. But that's sort of a roadmap issue that I don't think is ready for prime time right out of the gate as a requirement currently.
Got it. So I think, Robbie, if we were to pull, the idea of being a signatory, seems like there's agreement there. And also to Felix's point of being able to, meet the data sharing requirements, including social data.
Yeah.
Super supportive of that too.
I think why don't we pull together a draft for folks and we can circulate it with everyone for feedback. And I think just to your point, Felix, I also, read AB 133 is giving Cal HHS pretty broad leeway. But I did notice in the chat at the last implementation advisory committee meeting, or maybe it was the PMP, where Cal HHS staff noted that they believe they need statutory authority to both establish the data exchange board and mandate more signatories. So I think that's where Cal HHS legal counsel is, it seems. So I guess we'll see what comes out in the next ledge cycle. Well, awesome. Well, I think just moving on from there, on the same topic, Cal HHS did release the agenda for their next meeting on November 3rd. Which, just to note, does fall at the same time as our regularly scheduled meeting. So we're moving ours to Friday the 4th. But they will be, continuing discussion around PMPs, including that topic of QHIOs, as well as providing an overview of the grant programs, and the strategy for digital identities work will continue as well. So I think to that point, just I think following up as we did last time around, the listening sessions that Cal HHS is having, I think really reflects the need for education with stakeholders. During the listening session, they polled folks, and there's definitely lack of knowledge about the data exchange framework, lack of infrastructure and support, and then tech support, financing, education needs. So I think really kind of reflects Cal HHS's opinion that they need to, push up the education and TA grants as well. And that came through in what folks mentioned. I think just to state too, Cal HHS did push out the due date for the education grants for those seeking to apply to the 31st. And I think just to put a plug to, we're hoping as Connecting for Better Health to put in an application with some partners to be able to help support the education grants, through the auspices of this coalition and the forum we have. So, if folks are looking to apply, we'd love to figure out how to partner with you all, or at least coordinate to make sure, educational efforts with stakeholders, across the spectrum are aligned, as well as tailored to meet different audiences' needs. Would just note too that more information on the meetings that they're having are on the website. Next one's on the 3rd for the Implementation Advisory Committee. And then the next P&P subcommittee meeting will be next week on the 25th as well. So as Timmy mentioned in the chat, next meeting is on the 4th, on Friday the 4th from 11 to 12. So please, if you can, make that note in your calendars. And on the 17th, we're going to be moving our regularly scheduled time to 12 to 1 p.m. And this one will be more of our kind of policy briefing as we did last year. So rather than, our kind of meeting format, we'll be hosting it more in a webinar format with some speakers, and we'll make sure to follow up with more information for you all in our roundup and at our next meeting as to what we'll be doing during that regularly scheduled time as well. Additionally, we'd love for you all to save the date for the 16th between 3 and 5 p.m. We're super excited to be hosting a workshop focused on AAAs, so area agencies on aging, and the benefits that they can really serve in terms of helping with various Medicaid transformation and state, health reform initiatives underway, how they can participate in, want to sign the DSA, what will it take and what's the benefit that these organizations can provide. So we'll have that on the 16th between 3 and 5. Many thanks to C4A, Katie Weber, who's on the call, for your support and your expertise when it comes to AAAs, as well as to ITEP and Blue Shield as well, for their partnership in helping to put this event on. We'll have an invite out in the coming days for folks to be able to register for this event as well. And will this recording be available? Yes, we'll put it on YouTube probably later today or tomorrow, Jennifer, and we'll be sharing it out in the roundup next week too.
I'm sorry, I meant the webinar on the 17th or the 16th.
Yes. We'll have that on the YouTube as
conference. Well. Perfect. Thank you.
Yeah, not a problem. And then just a couple other updates to share with folks. So FIRE just came up earlier around the QHIOs. This is a big topic within the TEFCA context too. So they just released the first draft of the TEFCA FIRE implementation guide. It's open for public comment. We've got a hyperlink here to the Sequoia Project's website in case folks are interested in providing feedback to them. There also are some really great recordings available of events held by the Alliance for Health Policy and PBGH on the topic of collecting race and ethnicity data. So those are linked here. PBGH also put out a white paper to complement that webinar. So would recommend folks check that out. There's also a new coalition as well, Sync for Social Needs Coalition. I think something we'll reach out to them and, maybe be able to get them and some of their members to come present on the work that they're hoping to do around developing interoperability, for sharing SDOH information across care settings. Some big names are involved like NCQA and some government agencies as well. So check out that press release we linked to. And then additionally, ONC is hosting an information blocking office hours opportunity on the 27th. So recommend that, folks, especially if you're subject to the info blocking rule and have questions, ONC will have that opportunity available for you too. And then lastly, just looking ahead, as we noted next week on the 25th, there's a PMP subcommittee meeting at 10 o'clock. And the day before there will be just a tutorial or webinar for folks on the DXF as well. And I know we only have, about a minute left. Any final thoughts or questions before we adjourn for the day?
Robbie, I saw in the text asking if we had any subcommittees as part of this work that we can do some follow-up on some of these key topic areas. And we're always welcome to do that. If there is interest, we're happy to facilitate. We did that. We did so on identity strategy, identity management, and I think came out with a really good outcome there. So if there is follow-up and if there is interest, I'm assuming it might be around the reproductive conversation we just had. Just drop us a line, and we are happy to kind of think through how best to continue the conversation.
Excellent.
I think we're good. We stuck the landing, 11:59. I hope everybody has a great day and enjoy your weekend.
Bye.
Thank you.
Thanks, y'all.
Take care.